All right, thank you so much for staying with Daybreak. Let's get that conversation on the road, and we'd like to hear your thoughts on this. The hashtag is Daybreak at Trevor Ombija at Citizen TV Kenya. That's how we want to get your answers as to, do you think Parliament should be dissolved? This is the premise. LSK is pushing President Uhuru Kenyatta to dissolve Parliament because it doesn't adhere to the two-thirds gender rule. Simply put, they do not have enough women representation as envisioned in the Constitution. They've tried a record 4 times. Every single time they either come down short of quorum or simple basic support from the members of parliament themselves. Joining me now is one person pushing that agenda, LSK President Nelson Havi, who's with me. Thank you so much for making time this morning. And also Gladys Boss, she's the Washington Issue women representative, also with us on this conversation. Let's start with you, Havi. So you're pushing the president to dissolve parliament because it doesn't adhere to the two-thirds gender rule. Why now?
Well, Trevor, when the 2010 Constitution was promulgated on the 27th of August 2020, it was the expectation of the people of Kenya that all that was contained in that Constitution will be realized. It is now almost 10 years since the promulgation of the Constitution, yet Parliament has failed to do that which is required of it under the Constitution by enacting the two-thirds gender rule and ensuring that it is implemented. There have been 2 decisions of the High Court which have propelled this action by directing that the National Assembly and the Senate, as well as the Attorney General, take measures necessary to ensure that the two-thirds gender rule is effected. Now, the last of the decisions, insofar as this issue is concerned, was made by the Court of Appeal towards the beginning of last year. One of the petitioners who was before the court approached the Chief Justice with a view to ensuring that Chief Justice takes action in accordance with Article 261 of the Constitution. But the Chief Justice, for whatever reason, decided to give the 2 houses of Parliament some time, ostensibly because there were some bills pending in the National Assembly and the Senate. It is for this reason, and in light of that background, that it's quite evident that there is nothing more that Parliament and anybody, insofar as that issue is concerned, can do. And the only action that needs to be taken is for the Chief Justice to advise the President in the manner required by the Constitution to dissolve Parliament.
Let's bring in Shulei on this for a bit. And sorry, I missed you there a bit, Havi. We'll come back to you in just a bit. And you, Madam Boss, you've been serving in Parliament all this time. Is dissolving it the only solution now?
Yes, because I think all methods have been attempted in the past. There's been attempts to pass legislation. Each time it has failed. And we believe that there is lack of political goodwill to implement the two-thirds gender rule, because all it needs is for the majority party. By the way, Jubilee's page number 23, page 30 of its constitution states that it shall and is committed to ensure that the two-thirds gender rule is in fact implemented. So if Jubilee was committed, it would have been a case of whipping its members to vote in favor of that particular bill. But since that has failed, Article 261 of the Constitution says that if Parliament fails to enact any piece of legislation to implement any part of the Constitution, then anyone can go make an application to the High Court, which has already been done. So all measures have been exhausted. And I think, in fact, I think it's coming too late, because the Chief Justice should have already taken judicial notice of the fact that Parliament is unlawful as currently constituted. Because if you, and again I'll just refer, people must remember this, Article 3 of our Constitution says that every person has an obligation to respect, uphold, and defend this Constitution. It also says any attempt to establish a government otherwise done in compliance with this Constitution is unlawful. So what is happening in the country is unlawful. And this is not about women. It's about the rule of law. The president and members of parliament took an oath of office and swore to defend, uphold, and protect the Constitution. That is all we are asking them to do now.
Okay.
And
let me bring in Havi again on this. And Havi, I'll come back to you in just a bit, Madam Sholei. So dissolving parliament now, Havi, would essentially mean that Kenyans go back to the polls. Is that even plausible at this time of COVID-19?
Trevor, what Kenyans must understand is this. This is not an issue of plausibility. It is an issue of vindication of the rule of law. No wonder, therefore, all the three judges who have had occasion to handle this matter have been affirmative that there was a reason as to why the self-executing mechanism was put in Article 261. The law was designed in such a manner that it is compulsive, it's not permissive. It is not an issue that is at the discretion of Parliament. It's not an issue that is at the discretion of the Chief Justice or the President of the Republic of Kenya. It is intended to ensure that the aspirations, the wills of the people of Kenya are realized. And if I may take you a little bit back, in 2012, when the issue was first brought before the Supreme Court, the question was whether or not we needed to ensure that we have the two-thirds gender rule implemented before the election schedule for the 4th of March 2013. A majority of the of the Supreme Court judges were of the view that the implementation time ought to be extended up to the 27th of August 2015. The Chief Justice then was of the view that it had to be implemented before the election schedule for the 4th of March, for the reason that if it was not done that way, there was a possibility that the subsequent parliament will be unlawful. And it came to pass. So we have had two parliaments that are sitting on a shaky pedestal because they are not properly anchored in the law. And if you look at it from that perspective, you realize that this has to be done now. It is not an issue of whether or not we are prepared. It is an issue of ensuring that whoever takes the oath of office performs his or her obligation insofar as the duty to uphold the Constitution is concerned.
All right. Madam Boss, let me take you back to February 27, 2019, and the motion failed simply because of a quorum hitch. So out of the 75 women lawmakers in the National Assembly at that time, only 20 of them were in the House. And that even raised questions about the commitment of the KEWOPA, which is the Kenya Women Parliamentarians Association. Even though you say this is not a women issue, is there a commitment from the people who should be in the forefront pushing this agenda?
I think that the women, and you've had statements from KEWOPA before, have been very committed and also pushing for this to pass. But remember, even if all the women turned up in Parliament, we still don't have the numbers to pass the bill. And therefore, we are relying on the political parties to push their members and say, this is the position of our political party. We also expect the party leaders to take the front line in ensuring that people do turn up. And not everything that comes to Parliament will always pass. I mean, we've had other bills fail in the past. And therefore, that is why we are falling back on a provision of the Constitution, which is dissolving Parliament. And I mean, and the reason why I've taken this position is I tell myself that, I don't want to go down in history of being part of leaders who did not respect the Constitution. I think it's important that we put that point forward. Yeah, and because as it is at the moment, even the members of Parliament, each and every one of them, male and female, all took an oath of office to protect and uphold the Constitution. And therefore, if they have failed to do that, then let us dissolve Parliament, because that is the option that is available to us. Yes, as a member of Parliament, I wouldn't like to cut my term short, but it is important that this is, because it is something that we owe to history. History will judge us that twice we have failed to implement the Constitution. And if And I always say, when you allow people room to maneuver and not follow the constitution, it could be worse things that can happen in future, because you're setting a precedent where the constitution is not obeyed, and that should not be the case. It is, and this is a straightforward matter. It does not leave any room for the Chief Justice or the President, because it is clear under Article 261. There's been court orders 3 times. The courts have affirmed and reaffirmed that if the law is not enacted, then the Chief Justice should advise the President. It says shall, and it says also that the President shall dissolve Parliament. So there is no room for maneuver whatsoever. And if Parliament doesn't want to, if the leadership believe that it's too expensive to go to an election, we shouldn't dissolve Parliament, then they have the choice to pass the law. It is very simple. There are several formulas that have been presented to Parliament in order to, on the methodology of implementing that law. I have a bill that is still pending before the House that also attempts to implement the 2/3 gender rule. So if they don't want Parliament dissolved, simple, pass the legislation. It's very easy.
So, boss, walk me through, for argument's sake, let's say.
Have ministers. You cannot say, oh, we can't have ministers because it's too expensive. Or we can't have 47 governors because it's too expensive. So Treasury also needs to know they do not have a choice in this whatsoever. It is not for them to decide, because the Kenyan people already, when they passed and approved this constitution, that decision was already made. It is not for Treasury to pick and choose which parts of the constitution they feel they can afford or cannot afford. And even then, when we had discussions with the National Treasury, I told the National Treasury it will only take by 0.2%. That would be the increment. That would be by implementing the 2/3 gender rule. So, and that is why there is a thought that people can bend the rule of law when they want to. And that's why you have people like the National Treasury making such preposterous suggestions. And the message should go clearly to them. It is not for you to decide. If you think something is too expensive, then start a constitutional amendment process. But don't make the decision at your desk at the National Treasury.
All right, let's wind up this conversation, and I'll start with you, Havi, give you a chance for closing remarks. Is there a plan B should this fail, like all the other initiatives that have failed before?
This is a one-way ticket, Trevor. There's no plan B. It's for the Chief Justice to do that which is required of him under the Constitution. If he doesn't do what is required of him under the Constitution, then it will be evident that he will have misconducted himself. And under the Constitution, misconduct on the part of the judge, the consequences are set out there. What about the President? If he's advised to dissolve Parliament by the Chief Justice, again, there is no plan B. He just has to dissolve Parliament. If he doesn't dissolve Parliament, then there will be gross misconduct on his part. And the Constitution is also quite clear on the consequences of gross misconduct on the part of the President of the Republic of Kenya. The question will be, who will be the one to take charge of the gross misconduct on the part of the Chief Justice or on the part of the President of the Republic of Kenya? If we interrogate that question further, the people of Kenya know best how to handle this issue. I don't think they suffer want of expertise on how to wriggle out of the problem.
Okay. Boss, you guys have a plan in Parliament? Kewopa maybe? What are you mulling as options?
I haven't had a Kewopa meeting over this, so I can't say what the Kewopa official position is. But this is my position as a member of Parliament. My position, and as a lawyer, I know the law is clear on it. And therefore, I support the adherence to the Constitution. And Trevor, I think it's good to close by reading this out clearly to Kenyans, because they seem to forget. Article 261, subclause 7, It says if Parliament fails to enact legislation in accordance with an order under Clause 6B, the Chief Justice shall advise the President to dissolve Parliament. It says shall advise the President. It doesn't say may, it says shall. It's compulsory. And then it goes on to say, and the President shall dissolve Parliament. So the Chief Justice and the President have no choice. The law demands and the Constitution demands of them. The Constitution that they swore to uphold, protect, and defend has told them this is what they must do. So there is no room for maneuver whatsoever on both the Chief Justice and the President.
All right. Honorable Gladys Boss, thank you so much for speaking to us as the Wasindisha Women Representative. And also LSK President Nelson Havi says this is a one-way ticket and the President must now dissolve Parliament at this point. We'll follow up on this discussion and let you know what happens. We're taking a quick break here on Daybreak. When we come back, we're talking about something different. It's just about 2 days since the international flights resumed, about 2 weeks before after the domestic ones resumed. We'll find out from the people in the tourism sector how this has affected them and how travel will